Good morning. Welcome to the Judicial Committee of the Privy Council. This morning we are hearing an appeal from the Court of Appeal of Trinidad and Tobago in the matter of Betaudier against the Attorney General of Trinidad and Tobago. This case concerns alleged unlawful arrest and detention by the police. I'm Lord Lloyd Jones and I'm sitting this morning with Lord Hamblin.
Good morning.
And Lord Leggett.
Good morning.
The appellant, Mr. Betaudier, is represented by Mr. Anand Beharilal, Queen's Counsel, Sean McGibbon, Joshua Hutchins, and Kenneth Thompson. Respondent is represented by Tom Poole. Mr. Poole. I'm sorry, Mr. Beharilal.
Not at all. My Lord, I'm very grateful. My Lord, in opening this appeal, we adopt and pray and aid our written case. We say that the decision of the courts below is unsustainable, essentially because of errors of law in the test that they applied for false imprisonment, both in relation to the arrest and the detention subsequently, and in particular, the objective element in justifying the arrest and the reasons for justifying the detention. And as a consequence of that, they then failed to evaluate the evidence correctly, specifically the evidence given by Constable Mirage and Commissioner Ned, relying on speculation and failing to deal with an important gap in the evidence, specifically the station diary. Can I deal with the concurrent findings of fact points straight away? We don't dispute the principles and practice of the board. What we say is that the trial judge failed to apply the legal test correctly as against the facts that were placed before the court. Insofar as we do touch on the facts in the course of our submissions, in the supplemental bundle which the board has, if I could give the board these references, it's the supplemental bundle, page 7, and that deals with the case of Samlal. And essentially, I don't think this is controversial at all. If the board looks at page 7 of Samlal, it emphasizes that the judge has to look at the contemporaneous documents as against the witness's evidence. In this case, that would be the pocket notebook, the station diary, and if those are not produced, to consider whether an adverse inference ought to be drawn. Secondly, the case of Reed and Charles, which is in the supplemental bundle, page 133. And 133, simply, I put the red line on the left-hand side to assist the board. But essentially, it requires the court to assess the inherent probability and improbability of the rival contentions on the evidence adduced. And in this instance, the reason for the police operation and the actual intelligence upon which the police were acting. The final reference I give you is 144 in the supplemental bundle. This is the case of Ramsaran versus Houdan, all appeals from Trinidad and Tobago to the board, where the board made clear that if the determination was not justified on the facts found, this is the very last paragraph, the Court of Appeal should say so. And we say that the board is in a similar position, that if it agrees with us that the determination was not justified on the facts, that it can and should say so.
And so yes, Mr. Beharilal, there are, in the first issue of unlawful arrest,
yes,
there are essentially two issues, it seems to me, within it. One is the question of suspicion,
yes,
and the other is reasonable grounds for suspicion.
Yes.
Now, so far as suspicion is concerned, are there not, first of all, concurrent findings of fact as to the existence in the officer's mind?
Yes, that he suspected, or I'll take the board to the exact phraseology, but yes, kidnapping for ransom on the subjective element.
Yes, and moreover, it does not seem that at the trial, the question of the officer's subjective suspicions were investigated at all. The case of trial being that he was arrested by somebody else.
Yes, that is right. And this is why we don't challenge the fact that PC Maharaj and the court accepted, one, he was the arresting officer, and two, the reason he gave for the arrest. We're not
Right. So it comes down. Ground one comes down to reasonable grounds for the suspicion.
Indeed.
Yes.
The reasonable and probable cause. Absolutely. And with that in mind, my lord, it is worthwhile taking the board straight away, because we do rely on it, to page 827 of the bundle, which sets out the summary of the principles that we say are engaged in this appeal. And this is the case of Ramsey, page 827. And at the very top of the page, the relevant statutory provision, where a police officer with reasonable cause suspects that an arrestable offence has been committed, he may arrest without warrant anyone whom he with reasonable cause suspects to be guilty of the offence. And then at lettering B, little 2, it is for the arrestor to justify the arrest. And what we say, my lord, is that as far as establishing that reasonable and probable cause, based on what Constable Maharaj says he acted upon, they simply did not have reasonable and probable cause. And the reason we say that is that when one applies the Baku test that has been regularly applied in Trinidad and Tobago, none of the answers to those questions can be answered satisfactorily. And we cite it in our case at page 277 of the bundle. And it may be worth just turning that up so that the board has it in mind when I make this submission. Now, of course, the respondents...
This is the test from Baku.
Yes.
I wonder whether this overcomplicates the issue, because essentially the question is one of the existence of suspicion and the question of reasonable grounds for
it may not, my lord, but I think that I need to deal with this point, because the respondent suggests that this adds nothing to Ramsey. But it's important to understand that where the board is looking at this case and the approach adopted by the local courts, this was something that the parties relied on at trial. And so the board has reference to that. It's at page 141 of the notes of evidence, where the respondent and it seems the appellant address those relevant criteria. So this is E141, which is in the record. At page 18. Paragraph 18 and 19, going over the page. And also, again, just to give the board the reference, I'm not going to take the board to it in detail, E178, which is where the respondent specifically relied on this in submissions to the judge. And so, if I can take it shortly, no issue about what PC Maharaj has said. He's the arresting officer. He says he was arresting for the reason he identified. So when we address the reasonable and probable cause, again, we accept an officer does not need to have an offence in mind. He doesn't need to specify the section, chapter and verse, and so forth. But in this particular case, the officer did have in mind kidnapping for ransom. And so when the board and the courts below comes to examine whether reasonable and probable cause was established, it has to look to what the officer says he identified. And if it was kidnapping for ransom or some involvement in it, we say that the court focused insufficiently sharply on the requisite suspicion that Constable Maharaj should have had. And if the board turns to page 123, the phraseology used and accepted by the courts below is critical.
Sorry, which page?
123, paragraph 12. This encapsulates what PC Maharaj said. And what it comes to, my lord, is in the second line and the third line of that paragraph. Aroused my suspicion the claimant might have been one of the army officers alleged in the kidnapping ring, and the said monies might have been the proceeds thereof. Now, quite apart from the very speculative basis upon which he's saying that, when one subjects it to scrutiny and then looks at the last line where he says his opinion was strengthened in the light of the information I had received from Major Millington and my finding of an unlicensed firearm on the person of Corporal Stevenson, then we need to examine that and see whether there is any connection at all between this finding with Corporal Stevenson and the suspicion that Constable Mirage says he formed. And when you subject it to scrutiny, you can't see any connection. And we've made the point, and we emphasize this, if there was the genuine connection objectively or subjectively on that, then one would have expected that Corporal Stevenson would also have been arrested for the same thing. There is no connection between the two at all. And that brings, we say, the sharp focus onto the well-known definition of reasonable and probable cause. And if I could invite the board, please, to look at 196 of the bundle. Forgive me, 196 of the bundle, yes, maybe. And it's perhaps easier to refer to this because this is paragraph 50 of the judge's judgment, where he refers to the case of O'Hara. And he rightly identifies the case of O'Hara, no issue about this, but what is clear from O'Hara is that the test is partly subjective, partly objective. And in dealing with the second line in italics, the partly subjective, in that the arresting officer must have formed a genuine suspicion that the person being arrested had been concerned in acts of terrorism, and partly objective in that there had to be reasonable grounds for forming such suspicion. And although you can have a suspicion based on information received, the reasonable man must be able to accept that, having regard to all the surrounding circumstances, and regard them as reasonable for the purposes of suspicion. Now, the citation of the judge's principle was correct, but he then, we say, did not go on to apply it correctly, because the information from PC Maharaj and Major Millington simply did not demonstrate the appropriate information that they could act on and say that they were acting reasonably. And this is where the local practice and conditions of the courts below is important. My learned friend says, relying on Das and Marchand, that the court has to take those into account. We agree. And this is why we say that the court should look at the Attorney General versus Stewart, which we cite in our case. And could I invite the board to look at that at E279? And it's paragraphs 23 to 25. And what it comes to is this, is that once the officer has identified, if he chooses to do so, an offence, then it is relevant and important to look at the relevant offence, which appears to have been the focus of his mind. So this is not a case, we say, where the officer did not identify any offence at all. This is very specific. And could we invite the board, please, to look at page 390? Because this is the approach taken locally, where an offence has been identified. for the purposes of applying the relevant legal test. And this is the case of Stewart versus the Attorney General, Court of Appeal decision, and at page 390, it's paragraph 18. And in that case, where the arrest was apparently for being a member of a gang, the court was very careful, saying that taking into account the definitions of gang, gang member, gang-related activity, it was necessary for the appellant to show that PC Phillips had a reasonable basis for suspecting that, and then it lists three things. But the three things that are listed are essentially the factual matters that the officer should have had in mind if it is to trigger the appropriate suspicion for the purposes of gang membership. And the top of paragraph 19, so the first two lines, to prove reasonable suspicion, it is important to show a nexus between the gang members, in this case Stewart, Stewart's wife, and Kerwin Rock. Now, in that particular case, my lord, that didn't happen, because if the board then turns to 391, which is the very next page of the bundle, paragraph 21, the Court of Appeal, in then examining that, made clear that the details of gang activity, gang membership, nexus between the activity and the gang member and his role in the gang and in the activity are required. The facts put forward by PC Phillips never approached the detail required. And then it goes on to summarize the evidence in that particular case. And then if I could invite the board to turn to page 393, same case. Paragraph 23, bottom of the page, that's 393, paragraph 23. The Court of Appeal then examining this particular situation, the question therefore is whether there was sufficient evidence of Stewart's involvement in a gang and in gang-related activity to constitute reasonable and probable cause.
Sorry, where are you reading, please?
Oh, sorry, it's 393.
Yes.
Bottom of the page, paragraph 23.
Yes.
Where the analysis in relation to reasonable and probable cause is what we rely on. Question, therefore, is whether there's sufficient evidence of Stewart's involvement in the gang and in gang-related activity to constitute reasonable and probable cause for his arrest on the 27th of August. The fact of Stewart's convictions for drug dealing, which he admitted under cross-examination, would factor into the equation. But in this case, more was required because his arrest was for gang membership, not drug dealing simpliciter. Now, we say, my lord, that that is directly applicable here, because whatever was in PC Maharaj's mind, and we accept what the judge found, here there might have been a basis to arrest the appellant on suspicion of sale of illegal arms and ammunition. That indeed was the intelligence that they had to hand. But there was nothing for kidnapping, which we say, if you were going to arrest for kidnapping, more was required. And to use the words of Justice of Appeal Mendonça, that something more was missing from this case. As far as Stewart is concerned, we say that that is consistent with the position in England in the case of Clark. And if I could invite very briefly the court's attention to 587 of the bundle. This is 587, and it's paragraph 23 at the top of the page. First three lines. And the point we say is underscored even if this was examined in England. It says, although the power of arrest without warrant depends on the existence in the mind of the arresting officer of reasonable suspicion of the material elements of an arrestable offence, there is no requirement of law that the constable must have first-hand knowledge of these. So long as they come from a source which it is reasonable for her to rely on, they can properly form the basis of reasonable suspicion in the constable's own mind. And it's those words, reasonable, material elements of the arrestable offence, that are in play here, because where the officer identifies kidnapping for ransom or alleged involvement in it, we then need to then look, we say, at the Kidnapping Act to identify, well, what was the arrestable offence now engaged on the facts that Constable Mirage said he was acting on. And it's not possible to identify that on any of the sections in the Kidnapping Act which we've set out in our case. Now, that is not to say, and we emphasise this, that the officer had to have a specific statutory provision in mind. That's not what is required. But if I could invite the board to look at the Respondent's case. I don't have a reference for that. The Respondent's case in the bundle.
It isn't. In
the electronic bundle. The Respondent's case is in the electronic bundle. Forgive me, could I invite...
Respondent's case is at page 294.
294, I'm very grateful. It's 294. And it's, could I invite the board to turn to paragraph 13b, which is... Just going too far.
380.
I'm very...
It's page
302. 302, I'm very grateful. It's paragraph 13 of the Respondent's case. And again, we agree with what is set out there in law. He must reasonably, as far as Part A is concerned, as to having reasonable suspicion for suspecting that an offence has been committed, it is not necessary that officers should have in mind specific statutory provisions, nor mentally identify specific offences with technicality or precision. And it's not expected that an officer in the heat of emergency, this is B, should have in mind specific statutory provisions or mentally identify specific offences. But he must, in my judgment, and this is the important part, reasonably suspect the existence of facts amounting to an arrestable offence of the kind which he has in mind. And that, we say, my lord, has never been identified. And it is no answer, we say, that further questions ought to have been asked or could have been asked of the officer. That's not the law. The law is, once the arrest is accepted, it is for the arrestor to justify that arrest. So once Constable Raj and the Respondent was happy that that was the reason given, if it didn't meet the threshold, then they haven't justified it. And so when the board looks at that, there may have been some degree of confusion in the courts below as to where the burden of proof really lay. The relevance of the sections of the Kidnapping Act, such as they are, should have enabled us, and it hasn't, to identify which particular offence Constable Maharaj may have had in mind, based on what factually he was saying. Some offences are arrestable, some offences are not. Which one did he really have in mind? Forgive me, Lord Leggett.
This all doesn't have to be made too complicated, is it? It's really a very short and simple point. Was there anything which reasonably connected or could reasonably be relied on to connect the appellant to kidnapping, or wasn't there?
I agree. I agree 100%, and I embrace that, my lord. And I'll take much shortly, if I may. That we say is just not there, and if it was, it's not in the record. And if they couldn't satisfy that, then they fail at the first hurdle. But in any event, we turn to the objective element, and I say that this is even worse. Even if you could satisfy the subjective element, you couldn't get any further on the objective one.
Sorry, I was addressing the objective.
Yes,
I thought you'd accepted the subjective state of mind.
I do accept what Constable Mirage said, and I'm grateful. But I wanted to touch on this because we've put some focus on this in our case. What we know, and this is where the scrutiny for the purposes of the objective element was required. The board is aware of the standard rules that apply in a civil trial. You issue your claim, you file your pleadings, pleadings are closed, evidence is then filed, evidence is then closed, and the trial comes on. All of that happened here, except for one very significant failing. And it is one that the Respondent purports to rely on, and so I have to identify it. None of the documents that are in the record in the list of documents went into evidence. the station diary, the extracts from the CIU, the Magistrates' Court notes from the proceedings for Corporal Stevenson, none of these were adduced in evidence. And so before the court could carry out the application of the objective element, it would have needed to see the contemporaneous documents. And so that the board has the context, the station diary is roughly equivalent to the custody record that would exist in a police station in England. So it would chart the detention of a person, reasons for arrest, etc. And so that is why that document is so important. However, something went wrong, because not only were no documents put in, but the briefing document, even if it was redacted, that PC Maharaj purportedly relied on, was never introduced into evidence. It wasn't even in the bundle. And whilst information can, in principle, inform a justification, here you need to be able to examine it. And we just don't know anything about that briefing or how it would have enabled PC Maharaj to satisfy the objective element. And in this particular case, yes, I'm so sorry.
We just have to accept the evidence that was given and wasn't challenged, don't we, for what it amounts to, it doesn't.
Yes.
That there was a briefing.
Agreed.
And, but on the other hand, no doubt you make the point that there was nothing in the evidence of the briefing to connect these individuals.
Absolutely.
The activity, but there isn't really, the evidence is there, and we just have to look and see what it justifies or not.
Well, exactly. And perhaps if I can short-circuit it this way, the evidence such as it was did not make the connection. That was the point. There was nothing in the evidence about the briefing that would have had any bearing on this particular appellant. Now, can I, it may be important because the significance of the station diary, such as it is, I accept what Lord Woodbegget has said, is dealt with, and we refer to this local case, in the bundle, in the case of Bihari versus the Attorney General, page 473 of the bundle. And proceeding, of course, on the oral evidence, so to speak, if the board looks at paragraph 6, you can see the approach locally as to the significance of the station diary, of the pocket notebook, where we are dealing with someone's liberty. Now, that was a constitutional case, but there's no doubt that the standard documents in a false imprisonment case would be the pocket diary and the station diary. Inexplicably not adduced. There was some attempt by Constable Maharaj to say, well, he wasn't aware that that diary needed to be produced or had been produced, and that he tried to get it the Friday before trial. We would invite the board to look, please, which is where we say that this objective test could not be fulfilled, to page 15 of the record. And it's the bottom of the page on page 15, which is really to say that this couldn't amount to any kind of explanation that the judge could reasonably have accepted. Because if you look at the bottom of the page, page 15, Constable Maharaj gave the instructions for the settling of the defence, including the averments in relation to the information he acted on and why he arrested the appellant. And so he knew at the outset that these documents were critical, and the failure to provide them ought to have generated a stark adverse inference, as happened in the case of Bihari. But for some reason, it was thought that was did not need to be explained. As far as the information is concerned, could I invite the board to look at page 632? This is the case of Fox, and it's paragraph 32. And if I may digress for a moment, this argument was advanced by one Brian Kerr, Queen's Counsel, as he then was, paragraph 32. And it was an argument accepted. The reasonableness of the suspicion on which an arrest must be based forms an essential part of the safeguard against arbitrary arrest and detention laid down in Article 5.1c. The court agrees with the Commission and the government that having a reasonable suspicion presupposes the existence of facts or information which would satisfy an objective observer that the person concerned may have committed the offence. What may be regarded as reasonable will, however, depend on the circumstances. And what it comes to in relying of that is that looking at the circumstances in this case, the court's role in scrutinising the objective element on this essential part of a safeguard against arbitrary arrest and detention failed, and that protection is neutered if the court simply takes at face value what the officer says, that it was reasonable to rely on the information, without then looking at the substance or the credibility of that information, which suggested that it was right to arrest this particular appellant. And it certainly would be wrong to simply, we say, arrest the appellant because he was a member of the Trinidad and Tobago Defence Force, because then all such people are tarred with the same brush. Again, moving quickly, I'm minding the time, at 838 of the bundle, this is the local case of Roop versus the Attorney General. And it's 838, paragraph 21. Where the approach of the courts, and it's fairly consistent, and this is the last four lines, although the defendant pleaded details of the information given to Inspector George, there was no evidence to support the pleading. And as such, there was no evidence that the claimant was one of the persons referred to by the anonymous informant. Well, a comparison can be drawn here because there was nothing in the briefing that Constable Maharaj referred to that would have suggested that this particular appellant could even have been in the mix for an allegation of kidnapping. And most
other cases in which facts were found doesn't really help, does it? It's just a question of whether it was there were reasonable grounds.
Yes, I accept it. I accept that, my lord. And then if I may move to the actual information, if you like, that they had. And this is why this is somewhat contradictory on the respondent's case. When you look at page 133 of the bundle, we actually know in this case what information the police had. And this is the evidence of Major Millington. Page 133, paragraphs 4 to 6, and taking it in summary form, they knew that they had specific intelligence from a confidential informant that the vehicle, not the appellant, had been involved in the transportation of illegal firearms and ammunition. This is the most critical part on paragraph 4 and paragraph 5. The vehicle was under surveillance, it seems, for about 2 days at least. And on the day of the operation, the vehicle was continually under surveillance because there was information, according to Major Millington, that the vehicle was seen near a person reputed to be a drug trafficker. The informant said the vehicle was heading to Santa Cruz to either pick up or drop off ammunition. No information that it ever did. And when you look at paragraph 6 on the top of page 134 of the bundle, it's very clear from that paragraph that Major Millington imparted that information to Constable Maharaj, the arresting officer. So what Constable Maharaj actually had as the immediate information is that this vehicle had been under surveillance for 2 days, that it was suspected of being involved in illegal arms and ammunition, although no evidence that it actually did so. And more importantly, nothing about kidnapping. It was a totally different animal. And nothing to suggest a link to kidnapping. And so what we say, my lords, is that when you look at that, it is actually the evidence that the information they had was nothing to do with kidnapping. It was for a totally different matter. And so it did not, we say, bear scrutiny on the objective element. As Justice of Appeal Mendonça put it, and I would invite the board's attention to the judgment of Justice of Appeal Mendonça. This is at the bottom of page 233 of the bundle. This is the judgment of Mendonça J.A. And here, incidentally, this was the judge who gave the judgment in Harold Baku. If the board looks at the bottom of the page, line 48 on the left-hand side, the judge makes clear, applying the objective test we say correctly, the officer had no information the appellant had any involvement in any alleged kidnapping. He had no information over the page 234 in any of the kidnappings where a ransom was paid, which is critical to the formation of his suspicion. He had no information the ransom was paid in $100 bills, no information that if a ransom was paid, it was paid at any proximate time so that it might be reasonable that someone involved in the kidnapping would still have it in his possession in an envelope. I think it was also significant that Major Millington did not suspect him of involvement in kidnap. This is a man who's part of the defence force. In my judgment, there must be something more, and that something more is missing from this case. And I've already taken, my lords, to Major Millington's information, which he actually had and imparted to Constable Maharaj. And so what we say, my lord, is that even applying the anxious scrutiny to the second aspect of the subjective element, but in any event, the objective element, there was no evidence that could demonstrate reasonable and probable cause or ground a genuine suspicion. The best document that may have assisted, none of those were provided. And if that is what local practice demanded, the judge was wrong, we say, not to have made an adverse finding in relation to it. However, even without that, the evidence was not sufficient. My lord, I'm going to turn now to the detention because I want to move to that. Can I deal with any other matters in relation to the arrest at this stage?
I don't think so, Mr. Baharilal, thank you.
I'm very grateful. Even
if forgive me, if you're right on the first point,
yes,
then the detention was unlawful.
Absolutely. Absolutely. But as Ram Singh makes clear, the fact that the arrest may have been justified doesn't follow that the detention after would have been. And one of the things that went wrong, and this is why we address it separately, because we must as a matter of law, this is where concurrent findings of fact may not be engaged at all in this case, because for the majority to have dismissed the detention aspect following arrest, they included a fact which had actually been denied and never been proved at trial. One of the things that the appellant said was that he'd been arrested at gunpoint, he had been searched, he'd been strip searched at the station, and he was taken to his home where a search was carried out. None of these things were accepted by the respondent. In fact, they positively advanced the case, your home was never searched. And so that the board has that, could I invite you to look at the notes of evidence? And it's page 164. And if the board looks at the bottom of page 164, you will see the case put by the respondent. You were never stripped and kept in the nude for 5 minutes. You were never taken from the station to your home for the purposes of conducting any search. Your home was never searched on the 24th of December. Now, bearing in mind findings of fact that the appellant's evidence on this was not accepted, when one then turns to page 239 of the record, which is the Court of Appeal judgment, and this is the judgment of the majority of all of them in relation to detention. If you look at 239 line 26, which is the middle of the page, for some reason, the Court of Appeal felt that they could now incorporate the carrying of the appellant to the police station, and from there, his further transport to his home, where his home was searched. Well, one would have thought that if you are seeking to justify the arrest and detention, bearing in mind the information you have, bearing in mind it's a kidnap now alleged, there is one key characteristic. It should have generated the immediate reaction of the rescue of the hostage. So a strip search, a search of his person, immediate interrogation without an attorney to establish, has a hostage been taken? Where are they? We need to rescue them. It's fairly standard even in England to interview without a solicitor if that urgency for loss of life or risk of life needs to be addressed. None of that happened here. A search of his home would be absolutely essential if the police are acting expeditiously for the purposes of justifying the detention. But if that was rejected, none of that urgency is present. None of those things took place. And bearing in mind that those were the facts found, there is not any justification. And I'm going to deal with the interviews in a moment, but there wasn't any justification, as Ram Singh contemplates, on a minute-by-minute basis to suggest that the police were doing anything, any of those urgent things that justified his remand at the police station for 2 days, or 2.5 days. And this brings us, my lord, to the only explanation we say was given, the policy of not releasing until Commissioner Ned releases him or says, you can go. Now, we've made the points in our written case, but it's worthwhile just looking at Ram Singh again. This is at 826, because this is a point of law. Forgive me, 827. And it's the bottom of the page where the board accepted, quite rightly, the argument that the police must justify detention on a minute-by-minute basis. And that is informed, my lord, in England by the custody record, which creates the various entries throughout the period that a suspect is in custody. And in Trinidad, the equivalent document would be the station diary. Absent the station diary, there was no contemporaneous evidence to justify the detention, except what was left on Constable Ned's evidence, the blanket policy. And can I invite the board to turn to the very next page of the bundle? This is 828, where Lord Clark analyses that at C on the right-hand side, top of the page. but the blanket application of a policy under which it was, as WPC Collins put it in evidence, standard police procedure to obtain a medical report before a suspect is charged, the board accepts the submission that it would be wrong in principle for the police to adopt a blanket policy that suspects will always be detained until a medical report has been obtained, detained until it's been obtained. All must depend on the circumstances. Well, my lord, we've addressed the circumstances. If the court was prepared to reject that there was any investigative evidence beyond the interviews, and there was no urgency in the carrying out of those interviews, where is the justification? We say there was none, and certainly not on a minute-by-minute basis, and certainly not to justify from the 24th of December, holding him until the 26th of December. We accept that it's not, you have to look at the matter holistically rather than granular. It's a point that the respondent makes. We don't disagree with that. But you still have to provide evidence to show what is taking place while you've got this man in custody. And that wasn't done here. And the importance of that, my lord, is underscored. I've already taken the board to it. It's right. Could I invite the board to page 48? Sorry, Lord Hampden, forgive me.
It said that at the trial, the only challenge in terms of the period of detention was for the period of 6 hours beyond 48 hours. Firstly, do you accept that? And secondly, what's the significance of 48 hours?
Well, my lord, it seems that the 48 hours seems to stem from when the original arrest occurred. One of the things that was done in the pleadings was to put in issue separately the arrest and the detention. And it seems that the 48 hours may have related to the detention. But we say that that is not detrimental to the argument we make, because when you look at the pleaded case, what was very clear, my lord, is that the entire period was put in issue. So it's page 8 of the bundle, which is the appellant's statement of claim, paragraph 8, bottom of the page. In the premises, the aforesaid servants of the defendant, that's the police and the defence force, wrongfully imprisoned the claimant and deprived him of his liberty for about 56 hours. So he's put the entire period in issue. Now, that is important because one of the points that is made against me is Williamson, in which I had the privilege of appearing. But that is to misread Williamson, that somehow the issue was not put, or the question as my Lord Hampden summarised a moment ago, that there was a specific issue taken in relation to 48 hours. And the reason we say that is that once he had put in issue in his pleaded case that the entire period had to be justified, the defendant was on notice that it had to do that. And in fact, they did answer it, because when you look at their defence, you can actually see at page 14 of the defence paragraph 6, that the respondent readily understood they had to justify the whole period because they deny the wrongful imprisonment or deprivation of liberty for about 56 hours. They then go on to assert the justification for the arrest and also for the detention thereafter, pending reasonable investigations. And it's the pending reasonable investigations that the board will see at the top of page 15. So the respondent knew they had to adduce evidence of those reasonable investigations. And we say that it's not detrimental that the 48 hours was separately identified, because in this case, the claim put the whole period in issue and the respondent knew that. To the extent that the board's decision in Williamson is relevant, and a material distinction can be drawn. Could I invite the board, please, to look at page 966 and it's paragraph 10. And it was the difficulty in Williamson which I was not able to overcome, because it had not been included in his pleaded case. Lord Kerr at paragraph 10, although false imprisonment does not appear to have been pursued as a separate head of claim in the Court of Appeal, Mr. Biharal contended that it remained a viable element of Mr. Williamson's appeal. And then if you turn to page 969, you get the analysis that we say is applicable here. It's at paragraph 23. Bottom of the page, 969. While in a false imprisonment claim, the onus of establishing that detention is justified, rests with the detaining authority. The board is satisfied that for that onus to arise, it is necessary for a person detained on foot or on an admittedly valid arrest to raise the issue of the legality of his detention during a specific period, such as now canvassed on Mr. Williamson's behalf. Well, that happened in this case. Unlike Williamson, it was put in issue and it was responded to. And then to complete the point, if the board looks at page 970, the very next page of Williamson, paragraph 24, first couple of lines, it need hardly be said that the police do not have the power to detain suspects indefinitely. In other words, they have to provide that justification. But then the key distinction between this case before the board and Williamson is at paragraph 25, first 3 lines. The specific issue of the validity of Williamson's detention between the completion of inquiries and his being brought before the court should have been raised and were not. So had he pleaded it, he could have raised it. Because he didn't, that's why it didn't arise, which is not the situation in this case.
Mr. Biharal, you say there's no evidence at all here to show what investigations were carried out during the period of the detention.
I do, because number one, the interview that took place, the first interview, no evidence was adduced as to what had been asked of the appellant. All we have, and it is all we have, is the evidence from PC Catterson at page 130 of the bundle. And if this is the interviewing officer, he doesn't exhibit the interview notes. We know he didn't take a formal statement. But if you look at paragraphs 4 and 5, all it says is that he interviewed him. It doesn't say what he was asked. And that again brings into importance the station diary, because the station diary would have included the references to the interview and any notes that may have flowed from it.
But there is evidence that the interview took place.
All there is that an interview took place. In fact, the only person, my lord, who actually said what took place in the interview was the appellant Betaudier. And
why did the court need evidence of what was asked in the interview?
Well, my lord, if the court is looking to identify justification for the detention, then one would have thought that what was asked in interview was something that needed to be asked and that was cogent enough to justify the detention. It is not every case that one needs to detain for the purposes of asking questions. They can be asked at the time of arrest, after caution, and so on. And this is why I say what the appellant Betaudier said in evidence is important. Because when you actually look at page 163, this is the evidence of Betaudier when being cross-examined. He can't recall who interrogated him. This is 163, middle of the page. I was interrogated with regard to kidnapping. I don't recall who interrogated me. He says he's interrogated twice, and then he says this: I was not interrogated with regard to a specific kidnapping. Senior officer called out a set of names and asked me if I knew any of them. I did not know any of the names. Well, my lord, if that is all they asked him for the purposes of the interview, they didn't need to detain him for that. They could have asked that at the roadside. And since there was no other evidence as to what was asked, it is difficult to see how the interview such as was conducted, justified the detention, even in the first interview. But even if the first interview was justified, something then went dreadfully wrong, because after he is interviewed, we know that no evidence at all was given as to what was asked of Corporal Stevenson that may have been relevant, that might justify the further detention. What we do know is that after the first interview, he was not released. He was kept in custody. And we know, because this was the evidence, that there was no justification for that from page 127 of the bundle. And if the board can turn to 127 of the bundle, this is the evidence of Commissioner Ned, the senior officer in charge of the AKU. And if the board looks at paragraph 5, we can see there, as the senior officer in charge of the AKU at that time, it was my duty to identify if there was any evidence to support any further detention or inquiries. As a result, I reviewed the interview notes that had been recorded. At that point in time, I concluded there was no reason for further detention of the claimant. I spoke to Major Paul, who was the person for whom the claimant was the driver. I gave instructions he be brought to my office. Now, one would have thought, just pausing there, that it would have been to simply release him. But that doesn't happen. Instead, he then carries out another interview. Now, on the evidence that was given and accepted, if there was no basis to hold him, he should simply have been released. He certainly shouldn't have been detained for another interview. And so when one looks at that, one can see an admitted fact on these facts that there was nothing to justify the further detention even for the second interview. And that being so, where the Court of Appeal purports to say, as they did say, at page 239, this is at line 39. In the circumstances, in the context of a continuing investigation, it's 239, line 39, bottom of the page. In the circumstances, in the context of a continuing investigation, in the context of continuing efforts to ascertain the relevant facts, both on the interrogation of the appellant himself and possibly otherwise, up to his final exoneration by Mr. Ned at either 7:30 or 9:10 p.m., depending upon whose evidence is believed, we do not find that there is a basis for finding that the length of his detention was not justified. Well, my lord, we say that the Court of Appeal applied singularly the wrong test. They have to examine whether that detention was justified on a minute-by-minute basis on the evidence advanced. They didn't. And by the introduction of possibly otherwise, it is the greatest admission of speculation for a detention that one could hope to have, because there was no possibly otherwise anything. And if there was certainly no evidence about it. My lord, that being so, whether one looks at the first interview or the second interview, we just don't have the evidence on the findings that were made below to justify it. And insofar as the policy is concerned, and whether any submission was made as to whether a blanket policy is acceptable or not, we say that as a matter of law, a blanket policy is not acceptable, and that it could not be construed as justified that Constable Ned was the only person who could have released the appellant. And we say that because the law is very clear. If you're going to have to justify someone, justify the detention of someone in police custody, then you need to have in place procedures that would enable that person to be released if, in fact, there is no reason to hold them. Now, I'm dealing with this now because it is a I'm grateful. It's page 324 of the bundle. This is the extract from the Police and Criminal Evidence Act. Insofar as it may be argued and or have been accepted that there is nothing wrong in principle with having a designated senior officer to sign off the release of a person in custody, that has to be looked at very carefully. Because although in England, this is page 324, and that's subsection 34, subsection 3, even in England, the statute does provide for the custody officer to be the person who will release a person in custody. That's the designated person under PACE. That is heavily qualified, because it's qualified when you look at page 327 of the bundle, which is section 36 of PACE. And it's subsection 1. Custody officers at a police station, one or more custody officers shall be appointed for each designated police station. And even then, if the board turns over the page to page 328, subsection 4, an officer of any rank may perform the functions of a custody officer at a designated police station if a custody officer is not readily available to perform them. And we say, my lords, because so much of PACE reflected the common law, that also reflects the position at common law here, which is why Lord Clark in Ramsing was right to say you justify it on a minute-by-minute basis. Because if one person has to certify that the person in custody should be released, and they've designated that person, one, that person has to be available, or arrangements have to be made for someone to act in his stead if there is to be any review. Otherwise, what if Commissioner Ned hadn't come back for 2 days or 3 days or had been injured in the line of duty? Then this man would have remained in custody well beyond the 26th of December when he was in fact released. And so we say, my lords, that being the law, the only justification was a blanket policy which the respondent failed to justify. Could I pause for just one moment?
Yes, of course.
My lord, I'm finishing slightly ahead of my speaking time. Can I deal with any other matters in relation to the detention aspect of the appeal?
I don't think there are any questions for you at the moment, Mr. Baharilal. Thank you very much.
I'm very grateful. If I may make up my time if I need it later.
Well, we'll have to see about that. But I don't think we're going to be in difficulties over time. We'll take a 5-minute break now. Thank you both very much. Spool.
My lords, I'm grateful. If I may, I'll obviously deal first with reasonable probable cause and then with the question of lawfulness of detention. As to reasonable and probable cause, the respondent's overarching submission is that the majority of the Court of Appeal were right to uphold the trial judge's finding that PC Maharaj had reasonable probable cause to arrest the appellant. We say it is well settled that the absence of reasonable and probable cause is a finding of fact, not of law, and that is taken from the speech of Lord Atkin in the case of Herniman and Smith. I just give your lordships the reference, that's 679 of the electronic bundle. And so in respect of reasonable probable cause, we say that there are concurrent findings that should not be disturbed by the board in line with its normal practice. And as my learned friend has drawn to your lordship's attention, that practice was most recently set out by the board in the case of Das and Marchand, judgment handed down a few weeks ago, and that's in the supplemental bundle at electronic page 118.
Before we leave that, can we just look at Herniman and Smith's?
Of course, my lord. It's it's a malicious prosecution case where the main issue before the House of Lords was the function of judge and jury in that case. And I was referring to Lord Atkin at 679, where he refers back to the well-known judgment of Mr. Justice Hawkins and Hickson Faulkner. Now, this is obviously dealing with the test for a prosecutor. In my submission, when one looking at an arrestor and the question of reasonable probable cause, it is materially identical. And he says there are no paragraph number letters, but it's approximately 12 lines down. After quoting from Hickson Faulkner, it is well settled that the question of the absence of reasonable probable cause is for the judge. At the same time, it is, I think, clear that the question is one of fact and not of law. See Lister and Perryman per Lord Chelmsford and Lord Westbury.
Well, that's said in a very different context from...
My Lord, I readily accept that this is... My Lord, I readily accept this is, as I say, a malicious prosecution case, and it's dealing with function of judge and jury. But I say when one is looking at this question of whether there is reasonable probable cause, they are findings of fact that have been made below, first instance, as to obviously the subjective element of the test.
So as far as Das is concerned, was that concerned with question of reasonable probable cause?
Oh no, Das and Marchand is
Well,
entirely different context, but it's the most recent enunciation from the board of the normal practice not to.
Roy. Yes.
Yes, my lord, indeed.
Thank you.
And what I think it might be, and I appreciate the board probably has this well in mind, but what Lord Burrows was making clear in Das and Marchand is not only the normal practice, he described it as a super added constraint on the board that goes beyond the standard constraints on an appeal court and adds an additional hurdle for an appellate to overcome when appealing to the board. And that's paragraph 16 of Lord Burrows' judgment in Das and Marchand. It's supplemental bundle, page 126.
Thank you.
And I do say that in respect of both issues, namely reasonable probable cause and unlawful detention, the board is effectively being invited to determine an entirely different case than the case that was presented and determined by the court below. And I'll come on to make good that submission in a moment. My Lord Legate.
I entirely understand why you say the concurrent findings, which is, my understanding applies to questions of primary fact, operates in relation to what was in the arresting officer's mind, but how can it govern the question of what was reasonable or not?
Well, my lord, I do rely on the, as you say, the primary facts as to the, most importantly, when it comes to reasonable grounds, the 5 what have been called objective circumstances. Now, I accept. Sorry,
just to be clear, do you accept that the question of reasonable grounds is not a matter covered by the concurrent findings rule?
My lord, I would accept that they are not primary. Question of reasonable grounds, not a question of primary fact, but I do rely on the principle of concurrent findings insofar as it extends to concurrent finding not just of primary fact, which if you go to Devoy and Roy, it is not simply confined to primary facts. And I think in the Bank of Ecuador case.
Well, in the Roy case, the question was whether somebody come back from the dead, as far as I can recall, after hearing it here.
My lord, you're right. And in
that's rather different from whether something is reasonable or not, which is an evaluative question.
My lord, absolutely, of course it is. But what I do pray in aid of is what the board has said about not interfering with findings, concurrent findings below. And I accept, although not primary findings of, not primary fact, these are still findings that both the first instance judge has made as to reasonableness, and the majority of the Court of Appeal have upheld that finding as to reasonableness. And I say it would take a look.
Mr. Poole, to any authority where the Privy Council has applied the rule in Devi and Roy to a situation where there's an evaluation fault?
My Lord, if I can just dip into the Bank of Ecuador case. Yeah, well, what I had in mind, my Lord, and I think there's two versions of this case, because the wrong version was put into the main bundle. So I think the correct version of Bank of Ecuador is supplemental bundle starting page 9, and it's paragraphs 4 and particularly 5 dealing with this question, which is page 15. And there, the point is being made that you, as your lordships have made to me, very careful consideration must be given to the weight to be attached to the judge's findings and position, and particularly the extent to which trial judge has the advantage over appellate courts. Some conclusions of fact are, however, not conclusions of primary fact, but involve an assessment of a number of different factors which have to be weighed against each other. And this obviously goes to the point my Lord Legate and my Lord Jones was putting. Sometimes called an evaluation of fact, often a degree. And then reading on in paragraph 6 to McGrady, and then the conclusion of that paragraph on page 16. But even when an appeal is before the board, they serve as a reminder that the board cannot be expected to devote unlimited resources to re-examining every aspect of the trial process.
Well, did they in that case decline to consider the evaluated question?
Well, no, I think this was just a, as it were, a note of caution.
Right.
I readily accept that the principle applies to undoubtedly to questions of primary fact. My point here is where you have an evaluative exercise, that still weight must be attached to the trial judge, particularly where you have a question such as the question here of reasonable probable cause, and the trial judge has an opportunity to assess the witness, and it has been upheld by the majority of the Court of Appeal. But that's not, as it were, where I hang my hat solely. My Lord Legate.
Sorry, am I? Can you hear me?
Yes, we can now. We couldn't before, but we can.
Right. Surely, on the objective question, the evaluation of the witness doesn't come into it, does it? Whether the grounds were reasonable. Now, you evaluate the witness to decide what grounds he had. Once you've established that, it's an objective question.
My Lord, it is, yes. I accept that.
Right, thank you.
My Lords, I propose to deal with the matters as I've set them out in my written case in that order. So I do deal first with the facts, and I can take this fairly swiftly. They are dealt with at section B of the respondent's written case, which is at 296 of the electronic bundle. And I say there are two critical points to take from the facts. The first concerning the lack of any challenge to PC Maharaj's reasonable probable cause to arrest, and the second, the limited way in which the unlawful detention case was put in the lower courts. So I can just develop those 2 points briefly. Your lordships have this point already, namely that when one reads the notes of evidence and the judgment at first instance, it is quite clear that PC Maharaj's reasonable suspicion was not challenged at trial. And that is quite simply a product of the way in which the case was put below, where we can see the appellant's only real attack on the legality of his arrest was the arresting officer's identity. And he hung his case effectively on him being arrested by Major Millington lacking the power of lawful arrest, and that leading to the entire period of his detention being unlawful. And we see that from, if I just give the references rather than ask your lordships to turn them up, the statement of case at paragraph A, page 4, the appellant's witness statement at paragraph 11, which is page 118, the appellant's evidence in chief at page 161, and his cross-examination at 163. And it's to note as well, the appellant closed his case, and we see this from the notes of evidence at page 180, on the basis that if the court rejected his evidence, namely rejected it was Major Millington that arrested him, the court would still have to examine the defendant's evidence to determine whether he had reasonable and probable cause. However, PC Maharaj was never challenged on reasonable probable cause, and we see that from the notes of his cross-examination, and those are at 166 to 169. And we say, therefore, the judge was plainly right to find paragraph 44 of the judgment, which is page 194, that PC Maharaj's evidence as to the search and arrest of the appellant was first detailed and second, importantly, unchallenged. And that's, as I say, the finding at paragraph 44 of the judgment. And as we put it at paragraph 5C of our written case, page 297, there were 3 omissions in terms of what were put that are particularly notable given the way in which the case is now being presented to the board. First, there was no challenge to PC Maharaj's knowledge in the circumstances before making the arrest. The case that was put to him was he was not there when the vehicle was stopped. He was not the officer that searched the appellant, and he did not arrest the appellant. Namely, the focus being on the identity of the arrestor, namely Major Millington. Second, no questions were put about the kidnapping briefings on which PC Maharaj based his suspicion. So there's no questions about when, from whom, or any associated commands or instructions that were given. In my submission, I say that's particularly important given the significance that the appellant now attaches to the alleged inadequacy of the evidence regarding these briefings. Because PC Maharaj's evidence was that at least on 2 occasions he had received briefings from within the police regarding kidnapping and soldiers being involved in kidnapping. So that was his unchallenged sort of evidence. And the third point, dealing with the omissions from the way the case was put to PC Maharaj, there was no challenge to what he said to the appellant during the arrest. So notably, I think it's said by the appellant in the submissions to the Court of Appeal that he wasn't asked, the appellant wasn't asked any questions about the sums of money which were found on him or about any report pertaining to the kidnapping of any particular person. But there was absolutely no challenge to PC Maharaj's statement that what he found on the appellant raised the suspicion in his mind that further investigation was necessary. And there's another, I say, unfair criticism made in the appellant's case, that it is said that PC Maharaj subjectively considered $700 to be a large sum of money. Well, it was never put to him that it was not a large sum of money. And there was never any explanation given by the appellant as to why he was in possession of $700 in an envelope, all in $100 bills. So on this first point, I submit it's not open to the appellants, my Lord Legate.
Just a small point. Do you have a figure for us of what it equates to in US dollars? Or
my Lord, I do. Or rather, I did, because I thought I would be asked that question, and I've made a specific note of it, which I now can't.
You could come back to it at any time.
I'm grateful, Lord. I think probably my learned friend would be able to give me a precise figure, as he's more familiar with the exchange rate. But I have in mind that it's about £250. But let me come.
If it helps, it's £774.07 today.
There we are.
I'm grateful.
It's about 5. It's about 6 to the US dollar, isn't it?
It works out currently about almost 10 to 1, but I think it's a little bit less at the moment.
All right, so it's about 775 US dollars.
Yeah.
What was it at the time?
Pounds. Forgive me, pounds.
Oh, £775.
Yes.
There we are.
Yes, sorry, I found my note that I had scribbled on the statement of facts and issues. Yes, I had said £750, and I think that was at the time.
Right.
The second point that arises in my submission on the facts is in respect to the way that the unlawful detention case was put. And if I may just make these points now, and then I can come back to them when I'm addressing specifically unlawful detention. But we make these at paragraph 5D of our written case 298. And there's 3 points. First, there was no challenge to the investigations that were carried out by the respondent during the appellant's detention. Second, there was no challenge to the procedure requiring Acting Commissioner Ned to review cases before persons detained could be released. And we see that as a finding in the High Court judgment, paragraph 57, which is page 198. And third, we say that the appellant's challenge was limited to the last 6 hours of detention, it being the case that he should not have been detained for more than 48 hours. And we do rely on the Williamson case. And before I come to the Williamson case, perhaps I can just deal with the point that my learned friend has made in his submissions in answer to your Lordship's questions about the pleading. Now, I obviously accept that paragraph 8 of the statement of case puts in issue the entire period of detention, but that's because the case was that he was arrested by Major Millington, and Major Millington lacked the power of lawful arrest. So it is always going to be the case that he says that all his detention was unlawful. But that was not the way that the case was left to the judge. And we see that from paragraph 17 and 18 of the written submissions that were lodged after the evidence. And that's at page 156 of the bundle. And it's perhaps worth reading them sort of back to front and looking at what's said at paragraph 18 first, where it said it's not the claimant's contention that his period of unlawful detention and that's the whole period from 11:30 on Christmas Eve till Boxing Day. It's his contention his detention on the whole was unlawful because Major Millington and Corporal Antoine had no powers of arrest. Then if we look at what's said above that at paragraph 17, it's submitted that even if the claimant was in lawful custody of the police acted unlawfully in keeping him in custody beyond 48 hours with preferring a criminal charge against him. So that's why I say that the appellant's focus was on the last 6 hours of detention. And I do say that what Lord Kerr says in the Williamson case is of relevance here, and Williamson is at 962, and your Lordships have already been taken to it. So starts at 962 of the bundle, and in particular on this point, if I can ask your Lordships to look at paragraph 22, which is 969, where it says, given that the arrest was valid, counsel for Mr. Williamson accepted that if case for malicious prosecution failed, only claim in respect of false imprisonment which could be advanced was that between the time the inquiries were complete and the charge being proffered. It was accepted that the false imprisonment claim had not been formulated in that way before the High Court or the Court of Appeal, but it claimed it did not matter. And then Lord Kerr says at paragraph 23, while in a false imprisonment claim, the onus of establishing detention is justified rests with the detaining authority, the board is satisfied that for that onus to arise, it is necessary for persons detained on footing of admittedly valid arrest to raise the issue of legality of his detention during a specific period, such as now canvassed on behalf of Mr. Williamson. And then, if I may excuse for skipping paragraph 24 and picking it up at 25, if the specific issue of the validity of Mr. Williamson's detention during completion of inquiry's time of his being charged, brought before a court had been raised, evidence could have been produced to show that inquiries continued throughout the period between his detention and charging, not now open to Mr. Williamson to raise it for the first time before the board. So we do say that the way in which the case is put has a bearing on the respondent's ability to respond and the evidence that is adduced, particularly where a lot of onus is now being placed on what is said to be an unlawful blanket policy, which never formed any basis of the case before judge at first instance or the Court of Appeal. Now, my Lord Legate.
It's a rather peculiar feature of the case, Mr. Poole, that according to the appellant, a lot more investigation was done than there was according to the respondent, where hardly anything was done.
Well, my lord, you're right. It is that they are the competing contentions. It being the respondent's case that the appellant was taken straight to the police station. The appellant's case being that no, he was taken to his home. But
the findings were that the respondent's case was accepted.
Well, I think, in fairness, I think the first instance judge doesn't, although he finds that the appellant lacks credibility in a number of respects, particularly his account of being taken to his home and being held at gunpoint for several minutes. There was no express finding of the first instance as to sort of what happened to the appellant, whether he was taken home or not, because that wasn't, as it were, a necessary finding for the judge to make. But I suppose as good a point as any dealing with it here, the question of investigations, the findings that are made by the judge are those that are set out in paragraph 54 and 55 of the judgment, which is page 197 and 198, which, as the board will have seen, largely consists of PC Catterson's evidence of the interview and then acting Commissioner Ned's evidence. And those were the extent of the findings made as to the investigations, which the Court of Appeal unanimously found were reasonable in the circumstances to justify detention.
While we're on this point, Mr. Poole, what do
My
you
lord.
say about paragraph 5 of Mr. Ned, Officer Ned, paragraph 127, page 127? He reviewed the interview notes that had been recorded. At that time, he concluded there was no reason for further detention.
Yes, my lord. I mean, this is the difficulty that we have with that evidence not being tested in cross-examination, because we don't know the time that elapses between that review and the claimant being released at 9:10 p.m.
Well, you can't really blame that tested, can you? I mean, didn't have to test the fact that, and I see it's actually in the judge's findings that Ned concluded that there was no reason for further detention.
Yes, my lord.
So
If it's going to be,
there wasn't any justification for interviewing him again, was there, on the respondent's own evidence?
well, my lord, if it's going to form the claimant's case at trial, that period between him forming that view and him being released was unreasonable and therefore led to an unlawful detention, then that needs to be put to acting Commissioner Ned so that he can deal with that, and so that we can actually, so that we know the time that we're talking about.
Well, he did challenge the last 6 hours, didn't he?
Well, yes, he's challenged the last 6 hours as a block of time. But if it's now going to be said that sometime between 9:10 and sometime earlier there was no reason for him to be detained, and there was effectively a delay in communicating to him that he should be released, then that needs to be put so that can be dealt with by Commissioner Ned, who may have had a perfectly reasonable explanation for why, having formed that view, he then did not communicate it to the appellant until 9:10 p.m.
But it's Officer Ned who says there was no reason for further detention.
It's going to be sometime after 6:35 p.m. He doesn't come back to the office until then. So it's a pretty short period we're looking at. Is it not? That's paragraph 4.
Well, it is a very short period, and the sort of inference, or it would appear that Officer Ned took the view that he needed to speak to, obviously, the appellant, and spoke to him at an interview starting at 8:25, and then released him at 9:10. So, having formed the view that there was no evidence to support any further detention, it would, looking at what he says at paragraph 5 and doing the best we can, it's probably some short time before he then commences that interview at 8:25, which lasts some sort of 45 minutes. And I don't know that there's a complaint that that interview shouldn't have lasted 45 minutes. I mean, but this is why I do say it is important. It is not good enough to simply say we challenge without particularizing the basis of challenge a chunk of time of detention. My lords, the next sort of section of our written case deals with concurrent findings, but you have that set out in some detail in our written case, and it's paragraph 6. We set out the principles, and I've taken you to Das and Marchant and Devoy and Roy. I suppose the only point to draw out of Devoy and Roy that I haven't already is were it to be said that there is some significance to be attached to the fact that there is a dissenting judgment on the question of reasonable probable cause. I say it matters not that there's a dissenting judgment, because the issue is findings of the court, not of the judges who compose the court, and therefore a dissent by a member of appellate court does not obviate the practice set out in Devoy and Roy, and that's specifically said by Lord Thankerton at paragraph 2, which is page 619 of the electronic bundle. The legal principles on reasonable probable cause are not in dispute, save we do say that Ram Singh sets out the relevant principles, and it's the what is said there by Lord Clark at paragraph 8 of Ram Singh, which is 827. So I can then move on to reasonable probable cause. I didn't understand Myllenfriend's submission to abandon any part of his case on reasonable probable cause, although it might fairly be said that his focus is on the objective reasonable grounds. I didn't understand that he had abandoned his case on requisite suspicion or belief. So if you forgive me, and I can deal with these perhaps quicker than reasonable grounds, because the first question that we addressed in the case is whether PC Maharaj did have requisite suspicion or belief. And we say there are two answers to that. The first is the lack of challenge.
Forgive me, Mr. Poole, I may be under a misapprehension here, but I did understand Mr. Beharlal to accept that he was stuck with the findings as to the suspicion in the mind of the officer, the subjective suspicion in the mind of the officer.
My lord, if that's right, I'll restrict my submissions to reasonable grounds, and perhaps just.
I can see no sign of dissent from Mr. Beharlal at the moment.
Well, that's all.
I think therefore you can safely proceed on that basis.
I'm grateful, my lord. There's just there is one point perhaps to add to what we say at paragraph 13 of our written case, and it may be that this is unnecessary in light of our discussion, but I feel as though I should, just for completeness, when we are dealing with what is required in terms of requisite suspicion or belief, we say obviously it is put far too high by the appellants in their case, and I've cited a section of Archibald at paragraph 13 of our case and the case of Chapman. I should add to that the case of Abbasi, which is at page 363 of the electronic bundle. And it's I can give you the section of that case is 377, Lord Justice Purchase, where he says, I can see no mandate, this is little b and c on 377 electronic record. I can see no mandate in the common law for a requirement that a constable exercising his powers of arrest without warrant should specify the particular crime for which the arrest is being made, provided that one or more of such alternatives present to his mind were arrestable offences. Nor does the arresting constable have to impart the information to the arrested person in the form of a technical statutory or common law definition. So I just really fought for completeness, because that probably is as good a summary of the principle as I could find in the authorities, in addition to what's cited from Archbold and Chapman.
Thank you.
Well, then, dealing with belief on reasonable grounds, we pick this up at paragraph 16 to 21 of our written case, which is page 303. The first point that's taken by the appellant is reliance on briefings, and the main thrust of the attack is that PC Maharaj said he relied on information briefings he'd received on at least 2 occasions, and it said that that is sort of unreliable, and the evidence that was adduced on that was insufficient to give rise to reasonable grounds. Well, again, you have the point that PC Maharaj was not challenged on this, and it may be that this goes to the question of subjective, my Lord Legate.
Well, sorry, you actually anticipated. I was going to say that goes, we take the briefings at the full face value of the evidence.
My Lord,
the problem seems to be there was nothing in the briefings to link this particular vehicle or either individual in it to the kidnappings.
Well, my Lord,
they were members of the defence force.
Well, my Lord, let me then deal sort of squarely with that, and we deal with this at paragraphs 22 to 31 of our written case, starting on page 305, and it is the 5 relevant objective circumstances that gives rise to the reasonable grounds here, and we've set those out at paragraph 22, 306 of our written case, and it is those 5 factors in my submission that give reasonable grounds for PC Maharaj to arrest the appellant. So you have first the briefings, and the briefings were that army officers were involved in the operation of a kidnapping ring. And you have the references, and I won't read them out, in our written case to where PC Maharaj confirms that they formed his reasonable suspicion and that he wasn't challenged. You have then the second factor that several high-profiling kidnapping cases had occurred around this time, allegedly involving army officers. You have third, the discovery of over 7,000 Trinidadian dollars cash on the appellant's person in $100 notes in a envelope, separate to his own, one assumes his own cash, which he was carrying in his wallet, which, on any view, in my submission, PC Maharaj was right to consider is a large sum of money, and as he said, might have been proceeds of a kidnapping, i.e. a ransom. You have the fourth factor, the information that PC Maharaj received from Major Millington, that the vehicle in which the appellant was travelling was involved in transporting illegal firearms. Now, I readily accept there is no link between the vehicle and kidnapping, but there's a link between this vehicle that the appellant was travelling in and criminal activity. And when one takes that together with the other factors, that is clear in my submission to ground reasonable grounds for arrest. And then you have the, my Lord,
arrest for kidnapping, Mr. Poole.
Mm.
Yes, that's what we're
my Lord,
isn't it? Whether there are reasonable
my Lord,
for arrest for a kidnapping offence of some sort.
My Lord, yes, yes. So you have the connection. You have the connection with what the travelling in a vehicle that's connected with criminal activity. Travelling with someone that is found to have an unlicensed firearm. The link between army officers and involvement in a kidnapping ring, and that there are several high-profile kidnappings at present, allegedly involving army officers, and the finding of a large sum of money, which in his subjective view was not only a large sum of money, but might have been the proceeds of kidnapping. All of that taken together, in my submission, gives reasonable grounds. And, sorry, my Lord Legate.
But one difficulty I have, Mr. Poole, is the fact that the briefing which led to the arrest had nothing to do with kidnapping. It was all about transporting illegal arms and ammunition. And indeed, an unlawful gun was found. And the most likely inference one would have thought, the sum of money, is it had something to do with that. But do you suggest that one can infer from the fact that somebody's transporting unlawful guns that gives some indication that they're involved in kidnapping?
My lord, it's the connection with criminal activity.
Well, I accept there's a connection with criminal activity, but you accept, I think, that that's not good enough for you.
My lord, in and of itself, it might not be, but it's the combination of all of these 5 objective circumstances that gives rise to the reasonable grounds in my submission. And I readily accept the immediate briefing that led to this vehicle being stopped was relating to illegal transportation of ammunition. But that gave rise to this vehicle being stopped. Upon then the search, there was evidence found that PC Maharaj had reasonable suspicion to believe, led him to think that the appellant may be involved in kidnapping. And he then, as he said,
evidence what was found justified that belief.
Sorry, my lord.
Why did finding a sum of money and an unlawful gun justify or give any reason to associate that with kidnapping?
Well, my lord, it's not, with respect, it's not. Again, if it had just been those 2 factors, then possibly not. But it wasn't just those 2 factors. It is the connection between army officers and a extant kidnapping ring and knowledge of kidnapping, high-profile kidnapping allegedly involving army officers at that present time. So it's not one single factor alone. It is a combination of all of these 5 objective circumstances, as found by the judge and in fact upheld by all members of the Court of Appeal, that gave rise to reasonable grounds in my submission.
But if he didn't have reasonable grounds at the time of stopping the vehicle, what did the facts discovered add that could turn it into reasonable grounds?
Sorry, my lord, if he didn't have reasonable
grounds for stopping the vehicle on suspicion of kidnapping, what did the discoveries made add to the situation, which could then, in combination with what had gone before, create a reasonable suspicion? I mean, what does finding some money and an unlawful a firearm, add to the previous knowledge that now it gives reasonable grounds to suspect kidnapping when he didn't have it when he stopped the vehicle?
Because you found an unlicensed firearm, so you no longer have simply a briefing that's told you to suspect that this vehicle. You now have some evidence that the person in the vehicle has an unlicensed firearm. So there is then a connection on the face of it with criminal activity. And you then find on one of the people in the vehicle a large sum of money, which, as I say, PC Maharaj believed might have been the proceeds of kidnapping and certainly was worthy of further investigation. And that's what PC Maharaj said in his witness statement. He said at paragraph 13, which is page 123, he considered further investigation was necessary. And that again was his unchallenged sort of evidence. And under cross-examination, that was his confirmed that was his evidence, namely that further investigation was necessary. And that's page 167. And there's no question.
He subjectively thought it was necessary to arrest, but the question is whether he did actually have any. I mean, yeah.
Well, I say there's no question that it's permissible for an arrest to take place where the purpose is to interview or seek further evidence from the suspect. And you've got the authorities cited in our written case. It's Holgate Mohammed, which is at page 699, and Al Fayed at page 440. And in my submission, the learned judge at first instance was right to, having identified those 5 objective circumstances, to find that there was reasonable grounds, and the majority of the Court of Appeal was right to uphold that finding. And we deal with we deal with other points that are taken on reasonable grounds at paragraph 27 of our written case, page 308, where we make the point it wasn't simply the fact that the appellant was a member of the Trinidad and Tobago Defence Force that he was arrested. And we deal with the reliance on the case of Smith at little b. And we're making the point there that there are 5 separate factors that were present in PC Maharaj's mind at the time he arrested the appellant. And it's those factors taken together that was sufficient to form a reasonable suspicion and are objectively reasonable grounds to arrest. My Lord, if I can move on to lawfulness of detention. Again, we start from the point where we say the Court of Appeal now unanimously upheld the first instance judge's finding that the detention was lawful. And there are 3 criticisms.
Forgive me for interrupting. If we find that the initial arrest was unlawful, then that disposes of the detention as well, doesn't it?
It does.
Yes.
It does. If the arrest is unlawful, then it follows the detention is unlawful.
Thank you. But not vice versa.
No. No. It still lies with the detaining authority to justify detention. There's 3 criticisms made of the Court of Appeal, and by my learned friend, certainly in his written case, and I'll take those in turn. We deal with these at section F of our written case, which is paragraphs 32 onwards, starting at page 310. It is said that the Court of Appeal failed to correct the trial judge's sort of misdirection on the law and the test for unlawful detention. But we say we don't accept, for a start, that the trial judge misdirected himself. We submit he asked the right question, given the way in which the appellant's case on unlawful detention was put. But in any event, we say the Court of Appeal, it's accepted, applied the right test, namely whether the time of the detention exceeded that which is reasonably justified in the circumstances. And we see that from the Court of Appeal's judgment at paragraphs 13 to 17, which is page 239. The next point that's taken is the reference to what is said, reliance on what is said to be a blanket policy. Now, we do say, for the reasons we set out at paragraphs 35 to 39 of our written case, that this is not one of the exceptional cases where the appellant should be permitted to run this new argument, because it is an entirely new argument. And we say that for the 4 reasons we've summarised in those paragraphs. First, the appellant did not challenge the policy of continuing detention until the approval of Acting Assistant Commissioner Ned at trial or in the Court of Appeal. There has been a unanimous finding of the Court of Appeal that the policy was reasonable. And this is the local Court of Appeal being asked to consider this policy. And it's, in my submission, a perfectly sensible policy given the nature of kidnapping and the fact we make this point at paragraph 41 of our case. It is vital that suspects are not released too early. Page 312 of the record is the reference to where we say that in our case. And third, we say this is precisely one of those cases where it would have been of great assistance to the board to have the considered views of the judges of the local courts if this policy was going to be put in issue. And then finally, we say that had these appellants been advanced and raised in a timely manner, then the respondent might well have adduced relevant and helpful evidence, not least to the reasons for the adoption of the policy, of which complaint is now made. Although in my submission, one can readily see why such a policy was in place, as I've said, the importance of suspects in kidnapping cases not being released too early. And the third point of complaint that is made is that the Court of Appeal erred in failing to require the respondent to justify detention on what's called a sort of minute-by-minute basis. And we deal with this at paragraphs 42 and 46 of our written case, page 313. and it really boils down to 2 points in response. First, we say the board already has my submissions on why it's not open to the appellant now to raise this when it formed no part of his case below, because he only focused on the last 6 hours of detention. And you have what I take from Lord Kerr's speech in Williamson. But second point, we say that Ram Singh and Bihari are not authority for the principle that detention must be justified on a minute-by-minute basis. And I think there's probably common ground here, because I heard my learned friend say that he does accept that you have to take a holistic view rather than a granular view, which is a point that we make in our written case. So you need to take into account circumstances in which the detainee was arrested, the nature of the offence, the information the police had, the information the police may still need to obtain. All of those are relevant when considering the detention. But as we say in our written case at paragraph 46C, Bihari was a very different case to the present case. I mean, for a start, in Bihari, and it's probably sensible to have the case to hand. I give your lordship the reference to Bihari is at page 470. I mean, first and foremost, the policy that was in issue there, which was where there was a procedure in Trinidad where jointly charged defendants, you had to complete the entire charging process before bail could be accessed. That was the procedural policy that was in issue. And that's the first point. It was in issue. It was a live issue that needed to be determined. But the High Court in that case found that that policy was, I think they used the word unsubstantiated and unestablished and uncorroborated. And we can see that, I think, paragraph 7, page 473. And over to the top of 474. And then at paragraph 18, 478, no justification whatsoever for this alleged unsubstantiated general practice. That is not the case in the present case. Acting Commissioner Ned gave evidence to the effect that this was a policy implemented in the particular circumstances. That's reference for that is paragraph 6 at page 127. The policy was corroborated by PC Catterson. The reference there is paragraph 6 at page 130. And the Court of Appeal accepted Acting Commissioner Ned's evidence, and Mendonca, Justice Appeal Mendonca noted at 39 and 43 of the Court of Appeal's judgments, it's page 243, that the policy had been implemented to, quote, given the nature of the crime, particularly the high number of high-profile kidnappings at the time, that no one was to be released until Acting Commissioner Ned okayed it, as it were. So there's a real and important distinction between the facts of the instant case, where the policy on detention related to kidnapping suspects in the context of ongoing investigations, and the facts in my submission of Bihari, where the policy on detention related to granting bail to co-accused only once a co-accused has been formally charged. Bihari, in my submission, was manifestly unreasonable, whereas the same cannot be said of the policy in this case. And indeed, the trial judge and the Court of Appeal agreed that the policy was reasonable. And you have my point already that there was no cross-examination on the policy or the duration of detention, or whether investigations continued concurrently with the detention. Neither Acting Commissioner Ned nor PC Catterson were cross-examined on those points at all. So for all those reasons, I say that the criticisms that are made of the Court of Appeal in respect of their judgment on the legality of detention should be dismissed. And for the reasons I gave earlier and are set out in our written case, the appeal as to reasonable probable cause should likewise be dismissed. My Lords, I finished slightly ahead of my time as well. Unless I can be of any further assistance, they're my submissions.
Thank you, Mr. Poole. I don't think there are any questions for you at the moment. We're grateful. Thank you very much. Mr. Bahari.
My Lord, I'm very grateful.
Forgive me. Forgive me,
Yes.
Mr. Baharilal, I'm sorry.
Yes. Yeah, sorry, no, that's quite all right. Yeah. There's a case called Bihari, I think, in the book.
That's exactly the reason I
Yeah.
mispronounced your name. I do apologise.
No, not at all, not at all. Thank you. My Lord, what I would invite the board to look at just in response is page 194 of the record. This deals with the analysis or the evaluation of the challenge to
Sorry,
court.
page
194 of the record. It's the judgment of the judge.
Yep.
I'm just going to draw the board's attention to these few points and then touch on the law as to why it's relevant. It's paragraph 44, bottom of the page. And it's really when the judge is evaluating the evidence of Corporal Maharaj. He then deals with the failure to produce the station diaries, doesn't take any issue about it. But when you go to the bottom of the paragraph, last 3 lines, the evidence in relation to Maharaj that was not challenged was his evidence as to the search and arrest of Corporal Stevenson. But there was a challenge, as we know, to, I think it's Constable Maharaj, in relation to the arrest of the appellant. And the view of the judge, and we have to be cautious with notes of evidence, they're not verbatim, but what the judge says in relation to the appellant is that his account of his arrest of the claimant was not altered significantly under cross-examination, although he noted there were certain discrepancies. And I accept, of course, he was being challenged in relation to who arrested him, but he had been challenged on the arrest. And in addition, when the board turns now to page 191, the judge specifically considered the grounds that may have informed reasonable and probable cause. So we say it's no answer to suggest that the focus may not have been the same at trial. The judge clearly had in mind that the respondent needed to justify the arrest and therefore needed to establish reasonable and probable cause, which is why on page 191, paragraph 30, he identifies the 5 factors. And as we've said in our case, whether individually or collectively, it wasn't sufficient. You can have 5 different pieces or different comments in relation to what you thought about. But I'm afraid that if one of them isn't good enough, or each of them individually isn't good enough, putting them all together doesn't suddenly make it reasonable and probable cause. And this is where we say the judge went wrong, because when you now turn to paragraph 197, you can see the judge has he's carried out the analysis. He's looking for the justification for the arrest. And at 197, he then cross-refers to that paragraph 30 in saying, on the basis of what is in paragraph 30, I'm satisfied that he had the requisite suspicion. So whether or not the point was taken, the judge carried out the analysis. But if he was going to be true to the analysis, then the submissions we've made about the failure to demonstrate objectively reasonable and probable cause hold good. And here the judge's evaluation was wrong. While we are on this page, my lord, if you look at 197, the very top of the page, paragraph 51, the expression you listened to the words but didn't understand the meaning.
Forgive me, reference again, please.
Page 197, top
Yes.
of the page.
51, yes, got it.
I'm just saying, you know, the expression one listens to the words but didn't understand the meaning. The judge himself looked at Ramsing and considered the requisite proposition from Lord Clark's judgment that you need to justify the detention. In Ramsing, in the same part of the judgment as we've looked at, that dealt with having a blanket policy. And that's why it's worthwhile emphasizing, which is why we did this at the very beginning, whatever evidence was adduced, it is for the respondent to justify on that evidence the arrest and the detention. And in Ramsing, since it was made very clear, a blanket policy, as was made clear in Williamson, a blanket policy is not justifiable. And so if you're going to apply the case, you need to apply it properly. And when you look at page 198 of the judgment, which is in the record, 198, we can see he didn't. And it's paragraph 57 of the record, page 198, bottom of the page. What the judge has done in this paragraph is effectively reverse the burden onto the appellant. He says it's significant to note in the cross-examination of Ned, the defendant's attorney did not challenge his testimony that the complainant did not complain to him about any ill treatment by any officers, and that he did not put to this witness and that the claimant had been made to take off his uniform, stand in the nude, or even that he was made to pull his underwear down and pull it back up. Further, he did not challenge the procedure that required Ned to review the case before persons detained could be released. Well, my lord, it asks the wrong question. If the evidence is given in a trial that favours a judgment in favour of the appellant, why would you challenge it? They adduced the evidence of the blanket policy. They said, well, we're not going to let you go until I say so. We didn't need to challenge it. I can't think of any appellant in a false imprisonment claim who would want to challenge that. Rather, they would embrace it. And so it's perhaps a misunderstanding of where the burden actually lay. And we see it again at the next page, paragraph 58, 199. If you look at paragraph 58, top of the page, 199. In my opinion, the evidence adduced by the defendant to justify the period of time that the claimant was detained while the investigation was ongoing was logical and plausible and not unreasonable. Well, I've already addressed the board. There was no such evidence. But then he goes on to say, and this may be where he misled himself, no evidence was led to demonstrate that the claimant was kept for any reason other than the purpose of conducting investigations. And in my opinion, the officers acted reasonably and diligently in discharging their duty to conduct the investigations into such a serious matter. Well, we've already shown there was no conducting investigations beyond the interview. And so what was reasonable and diligent in that, we are left to guess. My lord, anything else? My lord, final point is this. The reason we have drawn the board's attention to the cases of Bihari and Kwamina and Stewart is because it illustrates the local approach. Two cases involving liberty, where that liberty is put in jeopardy by the state. And if I can take the board to the supplemental bundle, which has been placed before it, and it's page 126 of the supplemental bundle. This may be important in considering that local perspective, because in the most recent examination of the concurrent findings of fact principle, page 126 of the supplemental bundle, paragraph 16, bottom of the paragraph, Lord Burrows, in his second consideration, said this: the Privy Council wishes to respect factual circumstances peculiar to the country from which the case comes, especially, for example, local customs, attitudes, and conditions. Well, if that is right, and there's no reason to doubt the approach, then the judge had to adopt a similar approach to liberty being compromised, as in Stewart, and as in Kwamina, as in Bihari. And we see that in the case of Bihari, and this is the final point on this, page 481 of the bundle. And it's paragraph 29 of page 481, middle of the page. The judge, further, it matters not, except perhaps in relation to the issue of damages, that the length of time between the charging of the co-accused was relatively short. That is a difficult proposition to accept once one's constitutional right has been breached. It would be difficult to rationalize that to any person whose liberty has been deprived, and this the important part, for 1 minute or hour longer than is legitimately necessary. especially where the person in that case had an infant child, where the person has remained in unsanitary conditions. And so what we say, my lord, is that in deference to the local conditions and local approach, we know that the conclusion made by the judge was not reasonable in terms of the evidence he accepted in justifying the detention. And if we are to follow through on the local conditions, there is a clear line of authority from Trinidad and Tobago that you must properly justify the detention, and if you do not do so, then your claim to false imprisonment ought to succeed. Finally, this. If this decision is allowed to stand, we would say that this will become an authority for incredible abuse. We say that because you only need to substitute the characteristic soldier of Trinidad and Tobago Defence Force for another personal characteristic, red hair, Rastafarian hair, and then it would have been possible to arrest these people if that is what the obscure briefing had mentioned. And we would say that that is unthinkable and perhaps gives the strongest indication, my lords, that this appeal ought to be allowed. My lords, those are my submissions. Can I assist you any further?
Thank you, Mr. Baharilal. I think there are no questions. We're very grateful to counsel. We will take time to, I should also say, we're very grateful to those who metaphorically sit behind you or
yes,
slightly out of view, just off screen. Everybody who's played a part in preparing the cases, we're very grateful for preparation. We will take time to consider our decision. The court is now adjourned.
Grateful. Thank you.
Thank you very much.